The Socio-Economic Rights and Accountability Project, SERAP, got its on Wednesday when a federal high court sitting in Lagos ordered the federal government to immediately release information about public officials from whom public funds were recovered and the amounts seized to Nigerians.
The judgment was delivered by Justice Hadiza Shagari following a Freedom of Information suit brought by Justice Shagari, agreed with SERAP that the federal government has a legally binding obligation to tell Nigerians the names of all suspected looters of the public treasury, past and present. The group says the judgment shows the way forward in the fight against corruption and impunity of perpetrators. Now, SERAP's Executive Director, Adetokunbo Mumuni, joins us now for more on this. Many thanks for joining us on TVC News Hour.
It's a pleasure for being here.
Thanks for being here.
Indeed. Indefatigable you, really, now that you have this judgment. How does that make you feel in terms of the fight against corruption?
We are thankful to the judiciary. We believe that this is the way forward in the fight against corruption. We are even delighted by the fact that shortly after the Federal Executive Council meeting yesterday, the Attorney General said they will comply fully with the judgment. That to us is pleasing and satisfying.
All right, now, this court order not only is a victory for corruption, it is also a victory for the Freedom of Information.
Exactly, exactly.
Tell us about that. How do you, what's your opinion going forward with this bill?
The truth of the matter was that last year, the Minister for Information gave a breakdown of certain funds that had been received. Then we were surprised that the names of the persons from whom the funds were received was not disclosed. That was what made us write to the Minister for Information that we give him 14 days to disclose those particular things. And you see, under the Freedom of Information Act, once you make a request and it is not honored, you have within 30 days from the date that 7 days expired with them to go to court. And that was what we did. The case was filed last year. Only that judgment was delivered yesterday. The thing had been argued earlier. We believe that whatever it's what Nigerians deserve to know, the full information about what happens to anything that they have a right to be part of. In a democracy, like I continue to say, there can be no opaqueness. Things must be done transparently. And when you do it transparently, you leave out, there will be no doubt once everything is open.
All right. Your prayer was under Section 4, Paragraph A of the Freedom of Information Act. But let's look at some issues that could be thought-related effect or impact in terms of implementation of this judgment. The issue of defamation, the issue of libel. Where do you draw the line? Your name might have been mentioned, and they realize at the end of the day, you're not guilty.
Let me take it this way. Before you decide to return money, you understand, at least you are not forced to return it. Or if you kept it somewhere and it was discovered and was taken over. Now, you see, for every suit in defamation, I'm a lawyer, I've been a lawyer for 27 years. Truth is a defense. Fair comment on matters of public importance is a defense. Now, who will you sue in defamation? You can't sue the federal government who made the publication because it was made pursuant to the order of the court. That is definite. Once a court makes an order, it has to be complied with, otherwise the federal government will be guilty of contempt. Okay. So I don't understand how a suit in libel will come in. Libel is a branch of defamation when it is published. When it's spoken by what it is slander. So I don't know under what circumstance defamation will come. You won't be able to succeed because the federal government will say, I'm responding to the order of the court that said we should publish. As a matter of fact, the reason why they said they will not publish earlier is that some investigation are still going on, and then the constitutional provision that every accused person is presumed innocent until proven guilty. But the Freedom of Information Act makes it clear that if you are trying to protect a particular interest, if the interest of the public to know is weighed against such interest that you want to protect, and the interest of the public to know comes higher, then you have to release the information.
Okay. All right. Now, what's the ultimate for SERAP? I mean, after this order now, what will you do with the figures given by the federal government?
Exactly.
And the names? What will you do with them?
Now, you see, when you do the type of work we do in SERAP, you don't just receive information for fun. You analyze the information and you come to certain conclusions. If those conclusions that you come up will be a basis for further litigation, you do it. If the information you receive will be a basis for further advocacy in the line of your, you do it. So it is not information for information's sake. We want to engage the information that is supplied to us. We also want Nigerians to assist us in engaging with the information so that issues that arise from information given will be in the front burner of public discourse. Okay,
back to my argument. Maybe this would be a better argument if you situate it within the Criminal Act, the Justice Act, Section 81, where the proof of evidence lies on the prosecution in terms of the public officer having much more than what he has earned, or having appeared to even have much more than what, I mean, should accrue to him legally. The proof of evidence lies with the prosecution, and that the EFCC has not been able to prosecute effectively. Case in point, the Saraki case. That's what the CCT said. Now you mention my name that I have stolen money, and perhaps you take the money from me. And another case in point is that of the Ikoyi gate. You remember the noise was all over, really, before we understand that the money belonged to the government. How do you juxtapose that? No,
let me tell you this. In criminal prosecution, the burden is on the prosecution to prove the guilt of any person. Good. Let's take the Saraki case, for instance. A lower court, the court of first instance, has said he has no case to answer. The prosecution, Rotimi Jacob, is handling the matter for the federal government. He has appealed. You see, you can't say the federal government has really lost a case until the whole gamut of the judicial proceedings has been taken off. You go to the Court of Appeal. Let's hear the view of the Court of Appeal. It may be that the tribunal, Code of Conduct, now got it wrong. The Court of Appeal is there to check the record, arguments will canvass against the Court of Appeal. If the Court of Appeal says it agrees with the tribunal, the way to the Supreme Court, that is what the whole legal system, criminal legal system of Nigeria says, unless you don't want to appeal. So until we have a definite pronouncement on this matter by the Supreme Court, we cannot say one party had lost a case, because there is still the chance that if you... On the interim before the appeal, if you go by this your court judgment, they say, mention my name, I've stolen money, and you go to court and court said, you don't have evidence to prove that I've stolen money. In the interim, before the appeal comes up, what happens? Do I get an apology from the government? That should be the business of the government. It should not be the business of a social crusader like SERAP.
Well, this is one hurdle we have crossed, and we're quite happy, and of its success. Adetokunbo Mumuni, Executive Director, SERAP, well done, and thanks for joining us on TVC.
Thank you so very much. It's a pleasure being here.